Another, buzzword that comes up is trusts, and there's a multitude of different types of trusts. My understanding is, none of them are really a magic bullet here when it comes to Medicaid planning. But there's other aspects involved there as well. One of which is testamentary trusts, and the idea of, in particular, where you have a spouse, and some of the estate planning aspects that come up with protecting assets, particularly in the event that that community spouse were to pass away first. I mean, what are some of the considerations there, and where do trusts fit into this picture?
I'm really glad that you brought up estate planning in general and trusts in particular. So let's just start from a broad view on estate planning. The most important thing that anybody who might have long-term care in their future, which is a lot of people, 70% of people over the age of 65 are looking at some duration and form of long-term care. It all starts with your estate planning, and your estate plan should include either a will or a trust, and we can talk about the differences there as you just asked. But the other two pieces are a financial power of attorney and a healthcare power of attorney, sometimes called an advanced healthcare directive. All three of those play an independent and extremely important role in planning for the future, even if there is no long-term care. But the financial power of attorney might be the most important. That's one of the first things I look at, because remember all those strategies we just talked about, especially if we're making a gift, especially if we're buying an annuity, signing agreements for care. If the person who needs care is incapacitated, which is very often the case, they need somebody else to do that, all of those legal and financial decisions for them. That's where the financial power of attorney comes in. If they don't have one, the alternative is having to go to court for a guardianship, and that's expensive. It's cumbersome. There's time spent in court. Then there's reporting requirements to the state. So I can't emphasize enough that if anybody is watching this, they should ask themselves whether they have a complete estate plan, a will or a trust, a financial power of attorney, and a healthcare power of attorney. And they should really have one prepared because it's just very important for a lot of reasons. To answer your question about, the different kinds of trusts. So, often people will ask me, I spoke to my friend in Florida or my friend in California, and they said I shouldn't have a will, I should have a trust. And usually what that person's referring to is a revocable living trust. And it's one kind of alternative to a will. Usually, and if you were to even Google will versus a trust, you'll come up with these top 10 reasons to have a trust instead of a will. Probate avoidance always comes up on that list. And frankly, in states like Florida and California, probate is to be avoided because it's expensive. The fees you pay to the court when you just to even open an estate, it takes a very long time to settle a person's estate. So setting up revocable living trust is very common because it's a private agreement and it gets administered privately without having to go to court. So there's a very valid reason to have a revocable living trust. In Pennsylvania, the fees are very reasonable. So if you have something like $1 million estate, the fee to open probate costs like $600, which is not nothing, but it's in the scheme of things, that's fairly reasonable. Estates can be settled in a little over a year, and that's because there are built-in timeframes for notifying creditors that an estate has been opened and filing an inheritance tax and things like that. But it's speedy, it's not all that expensive. So if that's your only concern, a revocable living trust gives you no advantages for probate avoidance. It's just not really a reason to do it. But the more important question for purposes of Elder Guide is what kind of a trust do you need for Medicaid planning? A revocable living trust gives you no advantages for Medicaid planning because, if the whole idea is to say wall off assets and say, well, it's in the trust, it's not my money, it's the trust's money, therefore I should qualify for Medicaid. That's not the case with a revocable living trust. Those are all, anything in that trust is considered accessible by you because you are the trustee while you're alive. You control the money and therefore you can pay for your own care. However, some people choose to plan way ahead and set up an irrevocable trust, which is one where you are literally giving your money away. And that's a point that has to be emphasized for a lot of people because you're putting it in this trust and you're not the trustee, and distributions of the money are solely at the discretion of whoever that trustee is. So even if it's your child, and life will go on as normal, that, your bills will get paid and so forth. You're not the one making the call about when money gets spent or how it gets spent. So that giving up control is difficult for a lot of people to wrap their heads around. But the upside of it is that when it comes time to apply for Medicaid, you can truly say, I gave all my money to that trust. I don't have anything. Therefore, sign me up for Medicaid. One cautionary note is that's treated as a transfer, just like a gift is. So you have a little bit of a gamble that you're going to go 5 years and not need Medicaid because, you give that money away. That's a sizable transfer of money that would result in a penalty. As long as you make it 5 years without needing long-term care, you're in the clear. And that's a great planning strategy. For a lot of people, it's, because of their age or the medical condition they're in by the time we have this conversation, it's just not an option. But that is one planning option.
Right. You touched on a few interesting points there, one of which was you're talking about power of attorneys and any of these plans, whether it involves strategies of, gifting or repositioning assets or implementing these trusts, you have to plan for the possibility of incapacity for yourself. Obviously, I think that's probably one of these forms that people are most likely to have an internet form or something that probably doesn't meet the standards that are necessary, at least to do this kind of sophisticated planning that's necessary in the Medicaid context. But also, when you're talking about incapacity, there's the possibility of someone else in your family having issues or, being disabled. I just want to touch quickly on special needs trusts and how they fit in. I know they're not necessarily directly part of Medicaid planning, but they can certainly be relevant to somebody who has a disabled spouse or child. How do they fit into the bigger picture of this Medicaid planning strategy?
Yeah, that's a great question because one, we've talked about already transfers from one person to another of assets in order to spend down assets and become eligible at that $2,400 asset level. So one thing I didn't note is that assets can be transferred to a spouse. So you can transfer, certain amounts of money, or you can retitle an account or retitle a house into the name of the spouse, and that does not draw a penalty. The same is true of a disabled child who happens to be living in the house. So, or not living in the house. I mean, you can give to one of your children who is disabled certain property, and so that's one aspect of where people with disabilities comes into the picture of Medicaid planning. Even if you are leaving money in a will, though, or in a trust to a disabled person, that person might likely need Medicaid as well. So Medicaid planning is very much a reality for, let's say, disabled children with special needs. And that's a whole area where you need to talk to an elder law attorney who understands special needs, because it's a landmine where you can easily make mistakes, right? Especially when you consider children who are, say, born with Down syndrome or have autism, or somebody who's relatively young who is in a car accident and has a traumatic brain injury. They're going to have money to sustain them for a very long time. The life expectancy for even people with Down syndrome has grown significantly over the years. So who's going to sustain them if they're never going to hold a job that comes with medical benefits or has a nice amount of income to pay for an apartment or something like that? So even just as a part of your estate planning or Medicaid planning, you have to consider their Medicaid planning and their Social Security benefits, because giving any amount of money directly to a person with special needs will have a direct negative impact on the benefits that they might require to survive. So that's a very, so special needs trusts are generally how you do it. You don't give money directly to a person with special needs who needs SSI or who needs Medicaid. What you do is you give it indirectly to a trustee, and that trustee decides how to distribute the money to the special needs person. And there are other tools like ABLE accounts, which were only created in the last 5 years nationwide, and states are more and more implementing them. But they're a wonderful tool. Even if it's just to pay for food and shelter, which normally would cause a direct reduction in benefits. If you do it through the ABLE account, it's non-taxable and it doesn't affect public benefits like SSI and Medicaid. So anytime a person with a disability comes into the picture, I hate to say it's complicated, call me, but it is a landmine where you don't want to give money direct. If there's one takeaway, it's don't give money directly to that person, either put money into their ABLE account, set one up for them if they don't have it, put money into their special needs trust, and then have it go indirectly to them, but don't give money directly to them because that will reduce their eligibility for Medicaid and their Social Security benefits. And another thing, not only transferring the house for when the wife goes into care and the husband is not in care, transferring the house to the husband, but one other thing that you asked about that I don't think I answered earlier, which was, what about testamentary trusts, where you have a will-based estate plan, so it's headed for probate. That still is important because after we jump through all these hoops of getting somebody eligible and moving assets and drawing down assets, if say wife has gone through that whole process and is getting the care she needs, and then husband who was healthy in the community passes away, if his will just says, I leave everything to my loving wife, and her will says, I leave everything to my loving husband, that's a problem because everything that he owns is now putting her way over that asset limit of $2,400, and that blows her Medicaid, and now they're back to square one. Everything will have to be spent on the cost of her care. So you build in trusts so that everything does not go directly to loving wife. It goes into a trust for loving wife. And as you said, you can pay for certain things to enhance that person's quality of life without disrupting the benefits.